Hello.
Hi, Wes.
Greetings. Happy Friday.
Yes, happy Friday to everybody.
Hi, can you give me share screen? Well, that's interesting. So you can't log in and do the share screen or okay, bye-bye. All right. Does everybody have for some reason the share screen isn't working today? I'll fix that by next month. Does everybody have access to a bankruptcy code online?
Yes.
Or old school.
Or a book or whatever the case may be. All right. As I was preparing for class today, I realized that the previous edition of this book, which is the 6th edition, has a great discussion of what's a core matter, what isn't, what's related to a case, what arises in a case. So I'm going to distribute that for next class. For next class, not only will we discuss chapter 5, but we'll discuss an excerpt from the previous edition. Hey, Lucy did it. Look at that.
Okay. Thanks.
Very good.
What?
Okay, just give me a second here to get organized. So can everybody see this, like 1334?
Your fucking phone.
You can take him. You have to put his leash on.
What's that?
Get off your fucking phone.
You get off your phone.
Lucy, mute yourself.
There we go. Does that work?
Does he have a bag or something?
Yeah, he has a bed. He has a bag.
You're not gonna say bye?
I am.
Yeah, you are. Yeah, you're $90,000.
You've got Lucy, you have a hot mic.
Yes, it is. Yep.
So let's come back. John, can you see 1334 on the screen?
Yes, I can.
Okay, all right, so it works. All right, let's go back then. All right, looks like we have everybody here at this point.
I was not on mute.
All right, let's start.
You.
Today, we're going to look at a couple things. As far as the back of this chapter, last month we went through attorneys, and we were discussing the obligations of attorneys under 526, 527, 528. So we're going to be dealing with the first half of chapter 4 today. So let's start off with the jurisdiction of the bankruptcy court. And 1334 is the main section. Can everybody see it?
Yes.
Okay, when we talk of the bankruptcy code, we talk of Title 11. However, there are important parts of the bankruptcy code in Title 28 and Title 18 and Title 26. Okay, 1334A, except as provided in subsection B, the district court shall have original and exclusive jurisdiction of all cases under Title 11. What does that mean? Tinho, what does that mean?
Original jurisdiction of cases under Title 11?
And exclusive jurisdiction, original and exclusive. So what does that mean? That can the state court entertain a bankruptcy case?
No, they cannot.
So, B, except as provided in subsection E2, and notwithstanding any act of Congress that confers exclusive jurisdiction on a court, or courts other than the district court shall have original but not exclusive jurisdiction of all civil proceedings arising under Title 11 or arising in or related to cases under Title 11. I'm going to now pull up a picture. Let's see, can you see this chart? Tim,
Can't see the chart.
you
Can't see the
can or
chart.
cannot?
Nothing yet.
No,
I think
there's
you
not-
may have to switch the share screen to that other window.
All right, let's see. See, you guys are so smart. Okay, can you see this?
Yes.
All right. There are various scenarios under which disputes can arise in the bankruptcy court. And why this is important is because if it's not a core matter, a bankruptcy court cannot enter a final order to decide a matter, but instead can only make a recommendation to the district court, which of findings of fact and conclusions of law, which will then have to be litigated de novo. In other words, they're going to have to start all over again. So one of the most powerful things a defendant can do if sued by a bankruptcy trustee is to claim that the bankruptcy court doesn't have jurisdiction. Any thoughts on that? So
I have many thoughts
ahead.
on jurisdiction, but
Go ahead, Tim.
we'll save it.
Oh, okay. Like I said, I'm going to go into more depth on this next month. I look at a lot of exams, as I think I've told you, I'm a test taker, a guinea pig for both ABC and State Bar. I don't recall ever seeing essay questions on this, but this would certainly be fair game, for a multiple choice question. But looking at the chart that I've got in front of you, the bankruptcy court obviously has exclusive jurisdiction over the bankruptcy case, starting from the left. And the bankruptcy case is the case itself. In other words, you file a bankruptcy petition. Another thing they have exclusive jurisdiction over is litigation over property of the debtor or of the estate. If you are in bankruptcy, or if an entity is in bankruptcy, only the bankruptcy court can determine what is property of the estate and what isn't. Any thoughts on that? Okay, now we're going to move into non-exclusive jurisdiction. proceedings arising under the code. An example of a proceeding arising under the code is, for example, a contested relief from stay. If you have a contested relief from stay, it could only arise under the code because relief from stay only exists under the bankruptcy code. There's no other court that litigates reliefs or that has original jurisdiction to decide a relief from stay matter. Although that's one example, there are others, and certain issues can be remanded, as you see from the chart, to non-bankruptcy courts. Okay, moving on over to proceedings arising in a case under the code. So I'm in the middle now. What this means is, with regards to this contested matter, this could not exist if there was not a bankruptcy case filed. So, for example, an objection to claim under the bankruptcy code. In other words, the bankruptcy code has unique provisions, for example, for lease rejection, in terms of how you quantify lease rejection claim. Then moving all the way over, proceedings related to a case under the code. This is where this is going to be decided by non-bankruptcy law, such as a legal malpractice suit. So let's say the debtor is suing her attorney for legal malpractice. This would be a proceeding related to a case under the code because it doesn't arise under the code. Now, moving all the way over, litigation having no relation to the bankruptcy case. An example of this would be where a property of the estate is abandoned, let's say a house, and let's say there's a foreclosure and there's a dispute between the first trustee holder and the second trustee holder as to who gets what proceeds. The bankruptcy court would have no jurisdiction over that. Does anybody have any thoughts on this?
I think practically speaking, the bankruptcy court determines most of these issues anyways, because if the state court has no jurisdiction to decide what is or is not property of the estate, then the bankruptcy court's always the one deciding. And in my experience, all the times I've tried to argue the bankruptcy court has no jurisdiction, it disagrees, because in my view, the bankruptcy judges try to keep as much jurisdiction as they can, even if it's maybe stretching the statutes.
As a practice point, if you are in a situation where a court is trying to figure out whether they want to hold on to this contested matter or not, I think you need to give the bankruptcy judge a clear path and some idea of time in terms of how this is going to be decided. Because if this is some open-ended thing, it's a good chance the bankruptcy judge will punt and send it back to the district court or the state court or some other court. Any thoughts? Right. Okay. Let's go back to 1334. Okay. I'm on C. Except with respect to a case under Chapter 15 of Title 11, nothing in this section prevents the district court in the interest of justice, comity with state courts, or respect for state law from abstaining. So we're looking here, and at 1334C, this is the abstention clause. There used to be 305 of the bankruptcy code. Which parallels this. what this deals with is under what circumstance you will send something back to be determined in the state court. Typically, if a trial date has been set, the bankruptcy court often will abstain and grant relief from stay and allow the state court to move forward and decide a certain issue, with the caveat that no property of the estate can be levied on. Going down to D, this is an important practice point for everybody, and I think this would be testable. Any decision to abstain or not to abstain made under subsection C is not reviewable by appeal or otherwise by the Court of Appeals. So that's something to remember. When a bankruptcy judge decides to abstain, it's not appealable. Okay, when we were talking in the chart, remember I was saying only the bankruptcy court has jurisdiction to decide what's property of the estate. We find that in 1334E. The district court, in which a case under Title 11 is commenced or pending, shall have the exclusive jurisdiction of all the property wherever located of the debtor as of the commencement of the case, and over all claims or cause of action that involve construction of section 327 of the code. That deals with employment, which we talked about last month. Any questions on 1334? All right. Okay, I am on page 88 of the book. Okay, once again, they go into the fact that it's unfortunate that Congress has never made bankruptcy judges Article 3 judges, and instead they're Article 1 judges, so they don't have lifetime tenure, and instead they've only got a 14-year tenure. Moving on to page 89, we're now going to start getting into 157. As noted above, jurisdiction of the bankruptcy case and related matters is conferred on the district court by 28 U.S.C. section 1334. The process of referral, the relationship between the district court and its bankruptcy unit, and the exercise of power by the bankruptcy court is dealt with in 28 U.S.C. section 157. Section 157A allows the district court to make a blanket referral of all matters to the bankruptcy court. So, can everybody see that? 157? John, can you see it? Yes? Okay.
Yes, you can see it.
Okay, so each district court may provide that any or all cases under Title 11 and under any or all proceedings arising under Title 11 or arising in or related to a case under Title 11 shall be referred to the bankruptcy judges of the district. Is anybody on the Zoom call been practicing long enough to remember when the Delaware District Court took all the cases away from the Delaware Bankruptcy Court? Do you remember that? I don't remember why, but they did, and obviously they have the power to do so. Okay, let's see. B, bankruptcy judges may hear and determine all cases under Title 11 and all court proceedings arising under Title 11 or arising in a case under Title 11. So they have to be court proceedings. Now, this is the key part here. In 2, they go through court proceedings include, but are not limited to, matters concerning the administration of the estate, allowance or disallowance of claims, counterclaims by the state against persons filing claims, orders in respect to obtaining credit, etc. The problem is that under the, Grand Fin-Sierra case, just because Congress said it doesn't make it so. And this is certainly testable, and I think certainly a situation will arise where you're going to have to prove that you're aware of this concept, that this is helpful, this list under 157B2, but it is not dispositive, and case law is dispositive. Comments, thoughts? So,
We don't have it
Go
come
ahead.
up too much in practice. Seems like everybody consents now, and there's, a standard form that they pretty much waive it at the beginning unless somebody's really on top of it and for some reason very adverse to the bankruptcy court hearing it. But I can't think of the last time we didn't have a consent.
well, David, I agree with you. If you've got someone who's contesting this, you've got a fight on your hands. But for example, fraudulent transfers aren't necessarily core matters. What the test is, at the time the country was founded in 1776, what was a legal matter and what was equitable? I mean, it comes down to that. So there's all kinds of analysis of, for example, whether fraudulent transfer is a core matter or not. It says here, J, objections to discharges, that will always be a core matter because no other court can do that. Confirmation of plans, that will always be a court matter because no other court can do that. But some of these are kind of suspect. Okay, I'm on 3. The bankruptcy, go ahead.
Sorry, Wes, sorry, before you move on, so which ones would you say are suspect?
Let's see. Matters concerning the administration of the estate is a catch-all, right? So there's all kinds of stuff in there. Obviously, allowance to do disallowance of claims against the estate could be related to the case, so that's possible, possibly not a core matter. Counterclaims by the estate might be issues of state law. That might not be a core matter. Orders in respect to obtaining credit, it would seem to me, since that's under 364, that would be a core matter. If anybody disagrees, jump in. Orders to turn over property estate, that's a core matter. Proceedings to determine, avoid, or recover preferences. Now that's an interesting one. We used to have a preference statute in California, and like 20 years ago, it was deemed unconstitutional, which I thought was odd. So S&Ds, for the benefit of creditors, used to be able to file preference complaints. They can't anymore. That may or may not be a core matter. Motions to terminate, annul, or modify the automatic stay, core. Proceedings to determine, avoid, or recover fraudulent transfers, big question mark. Determines as to dischargeability of debts, core. Objections to discharge, core. Determine if the validity, extent, or priority of liens, I think that would be a question mark. Depending on the parties and the issues. Confirmations of plans, core. Orders approving the use or lease of property, including cash collateral, core. Orders approving the sale of property other than property resulting from claims brought by the estate, core. Other proceedings affecting the liquidation of the assets of the estate, that's a question mark. Recognition of foreign proceedings and other matters, core. Any questions, any thoughts? Okay, the bankruptcy judge, I'm on 3. The bankruptcy judge shall determine on the judge's own motion or on timely motion of a party whether a proceeding is a court proceeding under the subsection or proceeding is otherwise related. So this would determine what the bankruptcy court can do. If you bring a motion, what we're talking about is how far the bankruptcy court's going to go. And typically, if the motion was granted that it wasn't a core matter, typically the bankruptcy court will hang on to it until you reach the trial stage. Whether or not there would be, the court would hear a motion for summary judgment, I think is an open question. Tinho, do you have any comments on that?
Sure, the Ninth Circuit in the Health Central case said that the bankruptcy court can enter all pretrial motions, or can determine all pretrial issues, and therefore, even if you assert, for example, a jury trial right, they don't have to immediately send it over to the district court. And then in practice, what I've seen is the bankruptcy court will just hold on to it for as long as they can. And then depending on how long that's been, the district court will decline to take it on the basis of implied consent to jurisdiction. So in practice, it's very difficult to escape the bankruptcy court. And
Go ahead.
the district court, as far as I've seen, mostly rubber stamps the bankruptcy judge's report and recommendations like they would with the magistrate judge, because it's much easier for the district court to do so. They're like, well, the bankruptcy court knows all this stuff, considered all this stuff, so I will defer, unless the district judge is really bored.
Okay, let's talk about implied consent. If you object to bankruptcy court jurisdiction, you have to unequivocally say so. Otherwise, they're going to find implied consent. So go ahead, Tim.
And you have to say so very early on. And
Is
you
it
have to
14 days?
I think it's not necessarily a statutory requirement. Sometimes the local rules will have it, depending on the district.
You're supposed to
But
put it. You're supposed to put it in your answer, right?
yeah. But then even if you put it in your answer and you continue litigating in bankruptcy court, the district court can still find implied consent at some point. When you file a motion to withdraw the reference, one of the requirements is that it be timely filed before too much stuff happens in the bankruptcy court. And that's very squishy. So it's basically, if the district court doesn't want it, they can deny your motion to withdraw the reference. My suggestion would simply be to file the motion to withdraw the reference immediately and do no litigation in front of the bankruptcy court, because the more you litigate in front of the bankruptcy court, the less likely it is that the district court takes it back.
But do you agree that a bankruptcy court, if it's not a core matter, that it could still hear a motion for summary judgment?
Yes.
Yeah. Okay. Switching down to 5. The district court shall order that personal injury, tort, and wrongful death claims shall be tried in the district court in which the bankruptcy case is pending, or in the district court in the district in which the claim arose. Let's see. Is it Alida or Elida?
None of the above, Aleda.
Elida. How often have you seen a claim for a wrongful death?
Well, as it so happens, within the last year, I was a trustee in a sub 5 case where the catalyst was against a small aviation company, a personal injury lawsuit. So recently is the answer.
I've had one. I guess personal injury are much more common as well. But the thing is, it's so specialized, the bankruptcy court doesn't want to touch that anyway. Right?
Correct, and that was a big issue in this particular case. But they eventually settled, and it involved insurance, so yes.
So I had a case, I don't know, I think, John, you might have been involved on it, where there was the wrongful death with the Apache helicopter parts. I think you were my accountant. Anyway, what happened was we did a motion for substantive consolidation, which we'll talk about later on in the course, but the idea is to bring an individual with assets into a corporate case that doesn't have enough assets to pay creditors. And I was losing in front of the bankruptcy judge. So what we came up with was the idea of having the tort victim's attorney intervene in the substantive consolidation contested matter. They intervened, they brought a whole new perspective to it, and we won. But they had been litigating in district court. So, Okay, so let's go to C2. Notwithstanding the provisions of paragraph 1, the district court, with the consent of all parties to the proceeding, may refer a proceeding related to a case under Title 11 to a bankruptcy judge to hear and to determine and to enter appropriate orders and judgments. So the point is if everybody agrees, no harm, no foul. The bankruptcy court can hear the whole thing. Okay, now we're talking about what Tinho was talking about, D. The district court may withdraw in whole or in part any case or proceeding referred under this section on its own motion or on timely motion of any party for cause shown. All right, Aleda, have you had a withdrawal of the reference?
Not directly.
Okay, so let's talk about why this is important for bankruptcy trustees. Sometimes you get a squirrely debtor, and because who's flipping the bird at the bankruptcy court, and because arguably, bankruptcy judges don't have the power of criminal contempt to jail people, although some bankruptcy judges in the Central District believe they do. But I think case law mostly suggests they don't. If you've got a squirrely debtor, the way to put him in his place or get the case moving forward is to withdraw the reference, because a district court judge isn't going to fool around and isn't going to put up with any kind of tomfoolery that bankruptcy judges are used to. Thoughts? David, have you ever done this? Have you ever had to withdraw the reference?
No, I haven't.
Really? You haven't seen that?
Mm-mm. No, we don't have them pulled from us very often. I don't think the district courts like to get involved, honestly.
Well, that's the whole point, is that they don't, so they're gonna resolve it, assuming you have a good relationship. Go
So
ahead.
Wes, I don't mean to be flippant, but I'm here in South Florida, and when you say squirrely debtor, I mean, what kind of situation do you see that where, withdrawing the reference would make sense?
They've hidden assets and won't say, in other words, they have $1 million, the $1 million is gone, and they won't say what happened to it.
We have a couple of these types of cases, including that one of the judges in Santa Ana has sort of on his own, and sort of at request of the trustee, partially withdrawn the reference in order to initiate a criminal contempt proceeding against a vexatious litigant debtor. And the district judge actually appointed a prosecutor to prosecute the criminal contempt matter. Then it went up to the circuit, and then I think they got scared and stopped prosecuting. So it's been attempted. I don't know if it's worked for criminal contempt, because there's a prosecutor appointed, and then the circuit kind of put the brakes on that. But we have currently maybe 2 people incarcerated for civil contempt across all of our cases, and there's a couple of arrest warrants out for other people on civil contempt. So we have a formula for it. Works for civil contempt. Sometimes it's better than criminal contempt, because criminal contempt is limited in time and civil contempt is indefinite until they comply.
Aleda, I guess to take a step back, one of the themes of this course is don't be a victim. And you have to be imaginative and creative to be a Chapter 7 trustee. And if you find a door closed, go find one that's open. Moving down.
I have a quick question.
Go ahead.
So is that what they do in all of these high profile cases, like in, let's say, Lenny Dykstra or
I think they did, yeah.
So they withdraw the reference? Okay.
Incidentally, it has to justify that kind of attention. So if this is $100,000 case, no one's going to take you seriously. If it's a $10 million case, maybe. At our trustee seminar, John, yesterday, they were talking about a $5 million threshold, right? So, okay, let's go down to E. If the right to a jury trial applies in a proceeding that may be heard under the section by a bankruptcy judge, the bankruptcy judge may conduct the jury trial if specifically designated to exercise such jurisdiction by the district court. So what this does is this gives the bankruptcy judge the power to have a jury trial. Is anybody on the Zoom call ever witnessed or been aware of a jury trial in the bankruptcy court?
Judge Yoon said at one of our status conferences that as far as he's aware, no bankruptcy judge in the United States has ever conducted a jury trial.
Really?
That's what Judge Yoon said. So I'd believe that.
That's amazing. Yeah.
We all have jury boxes. He just says he's never seen it ever happen. He's not aware of any.
All right. I guess the practical reason is attempting to explain the bankruptcy code to a jury would be daunting. So I have participated in one criminal trial for violations of Title 18 by a bankruptcy debtor, but that was in district court. He was found guilty and fled to India. All right, any other questions about 157? All right. All right. Okay, I'm in the middle of page 89, and it says, I've got this highlighted. Maybe you should highlight it too. To qualify as a court proceeding, the matter must concern a right that arises out of and owes its existence to the code itself, or is so inextricably linked to the administration of the bankruptcy case that the matter, by its nature, could only arise in a bankruptcy case. It is constitutionally permissible for the Article I judge to decide core matters because Congress itself created the rights adjudicated in these matters. However, the bankruptcy judge may not render a final judgment in matters that are non-core proceedings, matters related to the bankruptcy case but requiring the resolution of non-bankruptcy rights. I'm on page 90. Therefore, where a bankruptcy court deals with a related matter, it must submit its findings of fact and conclusions of law to the district court, which must review them de novo. All right, and then it goes on. Going down to the bottom middle of the page, the bankruptcy court is permitted by 28 U.S.C. section 157C2, which we just discussed, to make a final judgment in non-core proceedings. Okay, moving over to page 91. As you know, appeals from the bankruptcy court, you can either appeal to the district court or you can appeal to the BAP. And this is actually a big decision. Daniela, do you have any opinions on that? In other words, whether you appeal to the district court or the BAP? I think you're muted.
I would think that if you want knowledgeable judges to decide, then you would probably want to go to the district court. But I don't know if there's just one rule. I've heard people mention that, but
Well, it's multifaceted, but in general, if you want to affirm, you go to the district court. If you want to reverse, you go to the BAP. The problem with going to the BAP is you've got people really interested in bankruptcy who might want to play with the case, and that's a real danger. So I haven't appealed to the BAP for some time. Actually, bankruptcy trustees in general don't appeal, but much prefer the district court. Tin, how often do your trustees appeal?
It depends on how mad we are, I guess, because some trustees are more prone to appeal than others, I would say. In a lot of cases, when you lose and you try to appeal, you end up getting much deeper in the hole. So usually we defend appeals. We don't affirmatively file
Correct.
appeals unless we're super mad.
Correct.
And then we usually lose those appeals, in my view, because it's not a good idea to appeal when you're mad.
Words to live by. I think there's a thought that being a trustee is a privilege, and certainly I view it as such. And it's an abuse of that privilege to be appealing. You've had your day in court, live with it, move on. So, okay.
Oh, and
ahead.
on the election issue, I think pragmatically the difference between the BAP and the district court is the district court is kind of a crapshoot in terms of how much attention the district judge is actually going to give you. And you will almost never have oral argument in the district court on your appeal. Sometimes they'll rubber stamp the bankruptcy judge. Sometimes they'll do something crazy. It's not very predictable, but what is predictable is they don't really care about your appeal. In the BAP, they kind of care about your appeal because they're bankruptcy judges and they actually know the law, and you'll actually have oral argument. So it may be a more structured appellate process. It may be a more predictable appellate process. The prevailing thought is that the BAP is debtor friendly, but I just think the bankruptcy code's debtor friendly. So if you know the code, you'll be presumptions in favor of the debtor. And the last thing is that if you elect the district court, no one can stop you. You can't elect the BAP and force people to go to the BAP over the district court. You can always elect the district court over the BAP.
So let's be clear on that, Chinho, because for what we're saying is if the appellant picks the BAP and the appellee picks the district court, you're going to the district court.
Right.
Okay. All right, moving on and going on to page 91 and 92. We're talking about Chapter 7 or trustees in general. And we've got section 321 of the code. And let's see. Whenever you see the 3 section, that can apply to Chapter 7, Chapter 13, and Chapter 11. So, and certain circumstances, Chapter 12. A person may serve as a trustee in a case under this title only if such person is an individual that is competent to perform the duties of a trustee, and in the case under Chapter 7, 12, or 13, resides or has an office in the judicial district within which case is pending, or in any judicial district adjacent to such district, or a corporation authorized by such corporation's charter or bylaws to act as a trustee. Now, let me stop there. Has anybody ever heard of Chapter 7, trustee being a corporation? Maybe a professional corporation, huh? Maybe that's what they're thinking of, as a professional corporation. David, have you ever heard of such a thing?
No, and we always, when we appoint people in other chapters too, we always appoint the person at the firm, never the firm.
When I get paid, as a trustee, my law firm doesn't get paid. I get paid individually. And then I just sign the check over to my professional corporation. Okay, a person that served in as examiner in the case may not serve as a trustee in the case. That would be a multiple choice question, so maybe we could remember that once you're an examiner, you can't be a trustee. And the U.S. trustee for the judicial district in which the case is pending is eligible to serve as a trustee. I think what this refers to is Chapter 13. Would you agree, David? In other words, if for some reason there's a vacancy the US trustee can be the Chapter 13 trustee.
Yeah, I mean, that's kind of the nightmare scenario, but I, I know we need to get the resignations well in advance to avoid that kind of situation. Even then, there's often an acting instead, though. But yeah, I think it's the final
That's what
batch.
I think the thrust is there. It would be in the, anybody have any comments on that? All right. Okay. Let's see. Moving down to the bottom of page 92. The trustee has to post a bond. In our case, in our district, it's a blanket bond for all trustees. And I think you're all aware that we, the trustees, we don't pay the bond. We take money out of each of our cases. And then that is used to pay our bond. We don't individually pay our bond. The code does not specify the standard of care to which the trustee must be held, and courts disagree on that standard. Some courts hold that the trustee is liable only for willful and deliberate dereliction of duty. Some hold the trustee liable for gross negligence, and some for ordinary negligence. And then they go into the case Liberty Mutual versus United States, which was an action on a bond, where a trustee knew of an asset and didn't administer it until it had been dissipated. I think trustees have to make decisions quickly as to whether you're going to no asset a case or not. I think if a trustee holds a case open without a clear path, she does so at her peril. And there's always the great case of insurance, because trustees are supposed to insure all estate property. But you do that with your own money. There's no money, so you've got to put your own money up to buy insurance policies. On a house, it's typically like $700 a month, which can get expensive. And obviously, if there's a loss and the property is not insured and the trustee has possession, the trustee's in deep trouble. That's why it's important to get possession quickly and to flip the asset as quick as possible. Are there any thoughts on that?
I'd just say, even if you're not monetarily liable under one of the harder standards, it definitely shows up on the trustee performance review and can get you booted in the long run. So I think there's the hard money liability, and there's the soft long-term liability.
Well, the flip side of this is if you're selling someone's house, you're selling someone's house. This is their life. You know, this is not a small matter. This is everything to them. And so I don't think trustees should be dithering in this situation, which I think puts more mental torture on the debtors. You know, I think they have to move forward resolutely. If there's a problem, you have to think of a way to overcome it quickly or abandon it and on to the next case. Removal of a trustee for cause. A trustee may be removed under section 324A for cause, which includes incompetence, violation of a fiduciary duty, misconduct, or conflict of interest. Let's see. Okay, here's 324. The court, after notice in a hearing, may remove a trustee other than the United States trustee or an examiner for cause. Whenever the court removes a trustee or an examiner under subsection A in the case under this title, the trustee or examiner shall thereby be removed in all other cases under this title. So this is the death penalty. I think you're aware of it, I assume. But if a trustee is removed in one case, she's removed in all cases, so that's the end of their career. I've never seen it. Has anybody on this Zoom ever seen it? I think if there is cause, I think what's probably going to happen is that the judge would defer to the Office of the United States Trustee, David, and this will happen behind closed doors. I think. I don't think this is going to happen publicly. Do you agree or disagree?
Yeah, I've never had one go through 324B, but we've had to have people leave the panel, and it's usually, yeah, done.
Well, that's your
in
job,
form of
right?
meeting.
I'm sorry.
Yeah, it usually is done not on the record. They'll resign and leave.
Right.
Yeah, because of the death penalty, like if you resign as trustee, you're not removed from all cases. So
Well,
they're
you
not
was-
they're
go
not
ahead.
going to sit on that and get removed in all their cases rather than just resign, because it's no individual case is ever worth it.
You resign for administrative reasons all the time. I'd say once a year, there's a paperwork screw up. Aleda, does that happen in chapter 11? Do you get that situation where you've been assigned a case in error and then you resign and then you give it to somebody else?
My personal experience, no. Although, on more than one occasion, the creditors see that I'm a different kind of trustee than a chapter 7 trustee, where my primary role is to facilitate a consensual plan, meaning I'm not
That's
taking
good.
take down the debtor. And then they try aggressively to get me disqualified or something or the other. And I've had some very interesting experiences in that regard. Because yes, we're different than most of you guys and who you represent.
Well, obviously, one way to get, I think we're going to talk about this in a minute, actually, before we're done. The one way to get rid of Chapter 7 trustee is through an election. That's how you get rid of a trustee, because a trustee starts out as an interim trustee, and then he says at the 341A, does anybody want to elect a different trustee than me? And then once in a blue moon, someone says yes. Usually it's a mistake on their part. And my next thing is, have you contacted the U.S. Trustee's Office? Because the U.S. Trustee's Office demands that you contact them before you stick your hand up at a 341A. Because once you stick your hand up at the 341A, the case stops. Okay, and now the U.S. Trustee's Office is going to have an election. David, have you given elections?
I think there's been one in the last like decade.
Really? In your office?
Yeah, so it's I'm pretty rusty on that.
Yeah. Well, before the bankruptcy code, they were very common. During the Bankruptcy Act, and back when the bankruptcy judges had their own trustees, bankruptcy elections were quite common, although I think the whole economics of bankruptcy were different back then. Okay, moving on. I'm at the bottom of page 93. The duties of a trustee in a Chapter 7 case are set out in section 704. So this is what a Chapter 7 trustee does. The trustee shall collect and reduce to money the property of the estate for which the trustee serves and close such estate as expeditiously as is compatible with the best interests of parties in interest. Be accountable for all property received, i.e. insure property as necessary. Ensure that the debtor shall perform his intention as specified in section 522A2B of this title. Let's talk about that for a sec. Has any of you who do debtor work, have you ever had a trustee contact you and say, has the debtor reaffirmed this agreement? No. Never happens, does it? No. So I guess it's all kinds of stuff we should be theoretically doing, but in practice is never done. Let's see. Investigate the financial affairs of the debtor. If purpose would be served, examine proofs of claim, object to the allowance of any claim that is improper. Our U.S. Trustee's Office talks about this quite a bit in terms of the responsibility of the trustee to go through and object to any proofs of claim that are, for example, past the statute of limitations. But sometimes this isn't easy because if a credit card is from South Dakota, what's the statute of limitations? It's a 6-year statute of limitations. So if it's a Citibank card out of South Dakota, they've got 6 years, not 4. So it's not so straightforward. One thing that people don't understand is that trustees, as a practical matter, don't object to claims until there's money at stake. You just don't blindly object to claims. And I guess some debtors have said, why don't you do that? And I guess because it's not efficient. If you don't have an asset yet, there's no reason to object to claims. Anybody have thoughts on that? All right.
Do you have creditors file claims in no asset cases? Like our pretty much tells them not to.
Oh, we have to, because our U.S. trustee will not allow us to administer any asset if there aren't unsecured creditors to pay. And it depends on the asset, but in general, if you're going after somebody's house, you have to have at least 25,000 in allowable unsecured.
I guess maybe I misunderstood. I was thinking you were saying in a no asset case that people were filing claims and expecting you to object.
Okay, well, let's talk about, actually, I'm saying that if something's, the debtor determines whether it's a no asset case to begin with. Okay, so it's a no asset case. Yeah, we'll file a notice of asset case, and then we'll try to get claims. And what happens is there are claims, I think I've discussed this previously, but there are claims clearinghouses that we email the debtor's social security number and mailing address to get claims. And we have to have a certain amount of claims before we can go forward. Tinho, what is your opinion if you're going after a house? What dollar amount do you have to have in claims?
My personal opinion, I guess, is there shouldn't be a dollar threshold, because if there's a claim and there's an asset, it has to get paid, right?
I know, but there's something called reality. So
I would say, given the administrative burden of actually selling a house and doing all the rigmarole, I would say, practically speaking, at least 20,000.
okay, so you're at the same place, man, Christy?
Oh, I think I was gonna answer his question that I have many no asset Chapter 7 cases and lots of times creditors file claims. That was it.
That happens, yeah.
Yeah, all the time, yeah.
I guess that they're hoping.
Yeah, they are, that's right.
Daniela, did you have an opinion on that? In other words, the threshold for a trustee to move forward?
Yeah, actually, no, I think it would just depend on the situation. So no, I don't really have a thought about that.
Okay. Well, if I'm under 20, unless there's something like massive fraud or something, I'm probably gonna go asset. The case.
So that means after you've given notice that it's an asset case, if no creditor files a claim, then you wouldn't.
Oh, if no, that's absolute, you're done.
Yeah.
Regardless of how many claims are scheduled. If nobody files a claim, you're done. All right, so let's go back and look at some more duties. Okay, if advisable, oppose the discharge of the debtor. funny enough, this is something that, in my experience, the U.S. Trustee's Office doesn't really second guess. David, do you second guess the decision of a trustee whether or not to go forward on a 727A? It would seem to me if you tell the trustee to go forward, they will. But if you're silent and the statute runs, I don't think you typically criticize a trustee. Do you on that decision?
I mean, I can't recall that coming
Yeah.
up. They usually keep us in the loop.
Yeah,
Okay.
I think that's a business judgment thing. You know, so if you decide for whatever reason, and in terms of what you do, whether or not you're going to file a 727, you look at what the debtor did, you look at whether the debtor speaks English, which I think is in some ways dispositive. If the debtors don't speak English, then I mean there's a defense right there. You look at the judge, dollar amount involved. But I file a couple of 727s a year. Okay, okay, if the business of the debtor is authorized to be operated to file with the court, the United States trustee, and with any government unit charged with responsibility for collection and determination of any tax arising out of such operation, periodic reports, and summaries of the operation of such business, including a statement of receipts and disbursements and such other information as the United States trustee or the court requires. How many of you, this is obviously, you bring the motion under 721. How many of you have been involved in a 721 hearing and a motion to operate a business? Tim, twice. What 721 motions were what?
Oh, that was not the number of times. We did one where Richard was appointed as the trustee of a skilled nursing facility. And so
That sounds bad.
yeah, it was right around pre-COVID.
That sounds
and
like a no asset case.
Well, it's an administratively insolvent case
Same thing.
because you know, we had to operate the skilled nursing facility to make sure nobody died. And that would be really bad if anybody died because, you know, it's just shoved onto you. We got a patient care ombudsman
Although that's
appointed.
why you have your patient care ombudsman to blame the patient care ombudsman if something died.
Well, the blame is shifted all around. So we operated that for like a couple months, immediately transferred it out to somebody else, and then 6 months later, boom, COVID. So thank God we got rid of that. And then in the back end, we sued people to try and recover avoidance actions. Still administratively insolvent, but not too bad. Not the worst case.
Well, if you're a Chapter 7 trustee and you've got a business that's operating that converts, the first thought you have is reconversion.
They filed it as a 7.
Oh, if they
So
file it as a 7, okay. If they file it, then same answer, convert to Chapter 11. Because if you convert to Chapter 11, all the strictures you have under 721 go away. And Chapter 11, you know, with the reporting and whatnot, is designed for an operating business. Aleda, any thoughts on that? Do you ever see Chapter 7s convert to Chapter 11? Whether it's an operating business?
From a 7 to an 11, no, I go the other way,
I've done it.
really.
Of course, then you have to say, pretty pleased to the U.S. Trustee's Office, will you make me the Chapter 11 trustee? But almost always they would say yes. So they'll go along.
I'm curious, under what circumstances that happened?
Because the value in an operating business is its viability. And no one's going to buy a business in Chapter 7. They're going to want to see it in Chapter 11.
I guess it depends on the kind of business, and the small businesses that I deal with, you know, the owner is the business, so you can't really.
Okay, my example was a wood flooring manufacturer.
And you have debtors with rental properties too, and so you can do that for a rental property just to keep it above water level.
Again, if you're a Chapter 7 trustee, you have to be imaginative. And you have to think outside the box. And you try to make things as easy as possible for yourself, and sometimes it's easier in Chapter 11. So, let's see. Beyond that, I will tell you that courts in the U.S. Trustee's Office really don't second guess you if you're going to operate a business. They say up to you. David, you have any thoughts on that? Or Tinho? David first, then Tinho.
Yeah, I mean, certainly as long as the reporting's coming in, I think that's the key thing.
Right.
Or at least.
Right. Are you doing all the U.S. trustee requirements? But as far as the actual business judgment decision, I don't think typically you second guess that, do you?
I think that's business judgment standard on that for sure.
Tinho?
I would say that's what the law is supposed to be, but I got yelled at by a judge because we filed a 721 motion, and the judge, who is now retired, said, if anything goes wrong, I'm going to surcharge the Chapter 7 trustee individually. So the motion was withdrawn after that.
Well, let's talk about that. You know you can be sued in state court, right?
Yes, there's that recent decision out of the California Court of Appeal that Rob Go was involved in. So that's terrible.
Yeah, so you operate, you can find yourself in small claims court or a superior court. So that, but I think trustees realize that, and that's one of the hazards of this. So, you know, being a trustee is not for the faint of heart. All right.
Would they ever appoint a receiver as opposed to?
Isn't there, is it in 543? There's a section of the bankruptcy code that says you can't appoint receivers. Is that 543? I think it, I'd have to go back and look, but a bankruptcy judge can't appoint a receiver. He can, the bankruptcy judge, he can keep a receiver in place, but the bankruptcy judge can't appoint his own receiver. Okay, let's move on. Okay, I'm on page 94, the trustee's role in Chapter 13 cases. The trustee is more concerned with other functions in Chapter 13, such as investigating the debtor's affairs, examining and contesting claims, recovering voidable dispositions, making recommendations on the debtor's plan, and ensuring its implementation. It's been my experience, and I'm not a Chapter 13 attorney or trustee, it's been my experience that the Chapter 13 trustees seldom, if ever, have adversary proceedings. I don't think they object to claims very much, and I think really they're just looking at the code and making sure the Chapter 13 debtor is meeting all the responsibilities of being a Chapter 13 debtor and the U.S. trustee requirements. Daniela, do you agree, disagree?
So I was just reading through something, so I didn't get your question.
Christine, what do you think? You're on mute.
Yeah, I apologize. Yeah, that was my experience. I don't do 13s anymore, but I did for a while. And yeah, they're not, I felt it was our responsibility to you know, challenge claims. And I didn't.
Right, that's what debtor does. Did you see in our district, they just put up the no-look fee to $7,000.
I did. That's amazing. I did. I still don't want to do them, but good for that. For
Can
everyone
anybody
else.
on the call? Can anybody on the call tell me what a no-look fee is?
Oh, just that they're not going to question it.
Who?
The U.S. trustees. Oops, sorry, the court or the U.S. trustees office. Yeah.
Right, or the Chapter 13 trustee.
Or the yeah, right.
Are no-look fees really no-look fees or no? David?
No, I think the court can always go back into it, and like our local rules have a bit of a range on it. And I'd also say we're a pretty Chapter 13 heavy district, not the most in Tennessee, but ours do go through the claims, and we see quite a few claims objections out of the 13 office. So ours are pretty proactive.
Okay. All right,
No, I think that the chapter 13 trustee would really only be interested. If a statute of limitations on a claim was coming up and they want to preserve that claim in case the case got converted to a 7, maybe. Like a preference action.
well, I can tell you, I get calls from a chapter 13 trustee's office maybe once a year. So seldom if ever. I think it's just done in mass, it's mass production line of 13 is just going through. Okay, appointment of a trustee, and maybe we'll finish up with this. So I'm on page 95. And let's look at the statute. Okay, at any time after the commencement of the case, this is a Chapter 11 case, but before confirmation of a plan, on request of a party in interest of the United States trustee, after notice in the hearing, the court shall order the appointment of a trustee for cause, including fraud, dishonesty, incompetence, or gross mismanagement of the affairs of the debtor by current management, either before or after the commencement of the case, or similar cause, but not including the number of holders of securities of the debtor or the amount of assets or liabilities of the debtor. Or if such appointment is in the interests of creditors, any equity security holders, and other interests of the estate. Those of you who practice Chapter 11, or later maybe you could jump in on this. It seems to me that 80% of the time, whenever you want to get a trustee appointed, it's a failure to follow U.S. trustee requirements. In other words, reporting requirements, or failure to file a confirmable plan. Thoughts?
Here in South Florida, especially lately, the bar is really low. Let me be. So it doesn't really happen. And my role as a subchapter 5 trustee, I try to have people work things out, and yeah, we work things out. Let me put it to you that way. And I was okay. So before I became a subchapter 5 trustee, I represented mostly government interests. I worked for I was a partner at a firm which represented mostly municipalities throughout the state of Florida, and I represented the government entities, and I pushed oftentimes and successfully so to get a trustee appointed. But we use the 362B4, the police power of the government and municipality for code violations and things like that. That was, one can do that at least in South Florida. If a debtor has just let a property go to pot, and people's lives are at stake, or the neighbors, or it's an issue, that is one of the ways. But other than that, you'd be shocked at what debtors survived here, the kind of incompetence at a minimum.
David?
Since sub 5, the trustee appointment motions have been largely non-existent, because that's largely what we draw as sub 5s, and
Right.
you can elevate the sub 5 trustee, but they can't file a plan, so that never seems to work out. I'd say in the pre-sub 5 world, we try to separate the cause from the remedy. So it really could be about anything that would lead to it, and then it was just a question of how viable is the business as an operating entity if we need a trustee in there versus dismissal or conversion.
Okay.
And usually the creditors had a lot of input on that, or the creditors committee certainly.
Yeah, this so long as it's not a small business debtor, that's the job of the creditors committee, is to inform the court and say we want to kill this, or we want a trustee appointed, and that has great weight. It's more or less 1:15. Any thoughts before we pick a date for next month? Does everybody have their planners or their Outlook handy? How does the 10th or 17th look to the group?
10th looks good for me. 17th, I'll be in a conference.
Is that-
17th is CBF.
You're gonna be at CBF? How about the 17th?
Well,
Any-
that is the day of
Yeah,
CBF.
I think they're both saying the 10th is good. Is that correct?
Okay,
10th works for me.
okay, is the 10th okay at noon?
Yep, for me, yep.
Okay, Lucy will be in touch with the certificates for today. Have a great weekend.
Thank you. Thanks
see
for the
you
class.
later.
Okay.
Bye-bye.
Thanks, bye, everybody.
Thank you.